Hey, good morning.
Good morning. SJC-13049, Joseph R. Mullins, v. Joseph E. Corcoran.
Good morning, council. Attorney Albano.
Morning.
Morning. May it please the court, my name's John Albano. I'm here on behalf of Joseph Mullins. This is the second of two cases involving disputes between the beneficial owners of Cobble Hill Center in Somerville. This case involves the same property that the court heard argument on last month, I believe, with respect to the question of whether Somerville had lawfully taken the property as an urban blight. In the first case, the first Cobble Hill case, Mr. Mullins claimed that the defendants were proceeding with the project without his consent. In this, the second case, he claims that his development proposals, among other things, were ignored to the detriment of the property. In the first case, the defendants prevailed on their counterclaims, and the court held that Mr. Mullins had, in fact, consented to their development. And the Superior Court awarded damages based on the value of Mr. Corcoran and Jennison's interests as of October 2016. That was the date, the operative date for all damages rulings, including mitigation.
May I ask you, interrupt you for a minute and ask you a question just for my clarification? I think in the original brief, you stated that the liability claims concerning post-2014 conduct were not actually litigated, but in the reply brief, it seemed to be limited. You were talking about post-2016 conduct. Do I have something confused or?
No, I'm sure that's my doing. The essential, it seems to me, the dispositive issue here is that the clock stopped in October 2016 with respect to Judge Salinger's rulings.
Okay.
What I'm sure I did not artfully explain in the first brief was that I do believe that as a technical matter, the liability claims were not resolved in Cobble Hill 1. And I would explain it this way. So Mr. Mullins moves to amend and supplement his complaint back in 2017. Superior Court says, no, these are new claims. No discovery has been taken on them. File a new lawsuit, which he did. The Superior Court in Cobble Hill 1, then, Judge Salinger, in limine rulings said, okay, that some of that evidence is going to come in, that evidence about development proposals that Mr. Mullins made. That evidence is going to come in not as to liability, but as to your affirmative defense of mitigation of damages.
Okay.
And so that evidence did come in, but it went to mitigation.
Okay.
It didn't go to liability.
Mr. Albano, Judge Salinger's rulings, at least as I think it was Judge Davis, the argument is that throughout the findings of facts and rulings of law, it's not just mitigation. It's addressing the issue of the eviction of the tenants. It's addressing the alternative proposals. It's even getting into issues about whether zoning changes would have occurred and the IPA has built issues. All of those issues are weaved in such that we should have issue preclusion here. Even though the motion to amend was denied, and even though the real issue from your perspective is mitigation. What's your response to that?
I think, again, the shortest and I think dispositive response is this, that the complaint in this case has specific allegations about proposals that were made in June of 2017. And there are no findings that Judge Salinger made after October of 2016. And if I could just explain a little more to make sure I'm clear on this. The appellees are absolutely correct that the June 2017 proposal came into evidence. It was, I don't have the exhibit number in front of me, but it came in to evidence. It was in fact offered by Mr. Corcoran. And they say, so it was all heard, it's all been wrapped up. But I respectfully say that can't be so, because life went on after October 2016. Things happened between the parties. We know things happened to this property. And the question on issue preclusion is, were these claims about 2017 actually litigated? There are no findings made by Judge Salinger with respect to life.
There's no findings made, for instance, as it relates to the eminent domain and blighting, and that's way after. I understand that, but the argument is that the relationship between the parties and the manner in which they're dealing with each other, how the Corcoran not talking to Mullins, and everything that would be within those claims are actually within the four corners of the decision. And I know you disagree with that, but why is it that they're not right? That the nature of the relationship, as it gets into issues of the breach of fiduciary duty, are really covered by Judge Salinger's decision. Why are they wrong about that?
Well, I would say they're wrong because it cannot be, and the law of issue preclusion does not hold, that rights are determined forever. I can sin here in my partnership and be held to account for it. It doesn't mean that next year and the year after, I won't have some legitimate gripes of my own. Even a force majeure event ends at some point. And here we had a relationship that continued. They got their judgment. They got their judgment that said, as of 2014, this project should have been built, and that by October 2016, here's your damages award. But the property didn't go away. The relationship between the parties did not go away. And because life continued, and I should also address, I think, why I've mentioned both in the briefs and here, the takings case and the fact that the property's been declared an urban blight. Appellees will say, and I understand why they would, hey, that's not in the complaint. You shouldn't even be talking about it. But if I could, I do think it's fair for the court to consider, in this case, those issues, because we have an allegation in this complaint. The derivative claim, for example, is all about there are decisions being made that are not properly protecting the property. Now, I think at the outset, the court, yes, can take judicial notice of the takings case and what happened to the property. But I would add to that, I think we're all in agreement. If you look
Counsel, can I stop you? Because I'm trying to figure out what's new. So you're saying, or what you're alleging is new. So you're saying the June 2017 letter, that's new?
That's new. That's
Okay,
new in
what
the sense
else? What
it's
else?
Well, the property's now an urban blight.
And that's in your complaint?
No, and if I may, that's what I was trying to, that's what if I could, I would like to
But,
address.
okay, so now, so it's a June 2017 letter is new. The fact that it's an urban blight, which is not in your complaint, that's new. What else?
The allegations of the complaint are that the defendants failed to consider the proposals made by Mr. Mullins, and it led to, that was to the detriment of the property. And we are now in that.
No, I've read the complaint. I'm trying to figure out what's new. What has not yet been decided in your estimation? So June 2017, urban blight, What else?
What hasn't been decided is that the property, well, no, that's a fair summary, Your Honor. What hasn't been
So it's the
decided.
urban blight, which is not actually in the complaint, and the June 2017 letter. That's
Yes,
what's new?
Except I would say it's fair to say that a complaint that says my proposals are being rejected and to the detriment of the property that hasn't been resolved in Cobble Hill 1 states a claim that is not barred by issue preclusion.
Well,
So,
no,
yes.
but yeah, no, yes and no. I mean, so June 2017 and the urban blight, those are the two new things.
Well, I think fairly read, the complaint alleges that Mr. Mullins is being ignored, frozen out to the detriment of the property, and that states a claim.
Well, yeah, but wasn't that claim one?
No,
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 What
because
was claim one.
claim one was, here's how it was explained below, Your Honor, by the defendants, the derivative claim, which was count 3 in the amended complaint that wasn't allowed, so it's now the derivative claim here. Count 3 adds a different theory of liability, focusing on the best
No,
interest.
I'm not asking you to quote to me what the defendants described your claim to be. I want you to tell me what your claim was.
I adopt their view, Your Honor, and I would restate it this way. It's a different claim because in Cobble Hill 1, Mullins is saying, you're going forward on this 214 project without my consent. In Cobble Hill 2, he says, you are letting the property die by not doing anything. It comes later in time. It's a different claim. It's never been resolved.
So let me ask you this, counsel. If we disagree with you, does the derivative claim go away as well? Do you all rise and fall on the individual and the derivative?
No, the derivative claim, well, I'm sorry, Your Honor, if you disagree with me that issue preclusion.
If I disagree with you that Mullins has stated anything new here that has not already been decided in 1, does the derivative claim survive?
It does, because the derivative claim is so different than what
Explain to
was
me how
litigated.
it is so different.
Because the derivative claim is that, if I can paraphrase, this property has been allowed to go to waste. That
And
is not.
I'm sorry,
that
and
is
how does
not-
that differ from the Mullins claim?
Because Mullins' claim was quite different, Your Honor. Mullins' claim was, you are proceeding with a development project that I do not consent to as of 2014. This claim, the derivative claim, is quite different. It's that, okay, you boys had your fight. You then ignored me, the property, for the following successive years, leading to the current condition of the property, which is to the
And how is that different from Mullins' claim in this case? Isn't that the basis of Mullins' claim? Like, yeah, I lost the 2014 fight, but now I want to bring an action for your failure to do anything with the property and bring it and let it waste away.
Right, I agree with you on that.
Okay, so that's Mullins' individual claim. What is the derivative claim? Isn't the derivative claim the same thing?
It's quite similar, Your Honor, and it may be they were both pled. It certainly could be that the court would determine on remand that it is all really a derivative claim, but not unusual to have a claim pled. Here is my individual claim. I have an interest that's been injured, but it also is to the detriment of the company. And that
Okay,
is.
so it sounds like what you're saying is that the derivative claim and Mullins' individual claim in this case rise and fall together.
That I think that's fair, Your Honor, that if the court says that neither the company nor Mr. Mullins is entitled to pursue a claim that the proposals about what was best for the property were not pursued by the majority, and that neither the company nor Mr. Mullins has the right to sue over that issue, then I have to face, I lose that one. If the court says nope, but may I just say this? How can that be? The Cobble Hill 1 findings stop in October of 2016. Life did go on. There were other opportunities to develop this property.
Right.
And it
Counsel,
never,
I understand your answer to Justice Wentland's question, but can you go back to the issue of the derivative claims falling if the major claim falls? Aren't you arguing that there's a difference in the parties?
that's very fair, and I'm sure I
just want to make sure you know you conceded that.
This is the issue, the whirlwind issue, and here is my position on that. The restatement says that often if it's a closely held corporation, an individual claim may bar a derivative claim, unlike if you're a shareholder of IBM.
Right.
But it's very fact specific. And the comments to Section 59 really talk about preclusion when the plaintiff is the majority owner. The examples are a 95% owner of a closely held corporation sues in his or her individual capacity. That, the restatement says, should bar a essentially similar claim on behalf of the company. And that applies here. Mr. Mullins is the minority owner, so that presumptive rule should not apply. But at a certain point, because I do concede, the issue of when does a derivative claim become so close to an individual claim is really quite fact specific. My position here is that this derivative claim is at a bare minimum the claim that should survive because the property has been harmed, the company has been harmed. In that case, has never been tried or resolved. On the issue of whether
your position is whether Whirlwind is 128 or not, whether the restatement is limited to a situation where the individual is in a different position as matter of control and power of the closed corporation, that the derivative suit, no matter where we come out on that doctrine, should survive because mitigation aside, the issue just has not been addressed in long and short of it as to the condition of the property after October of 2016.
That's correct, Your Honor. And I would, another way of saying it would be, I saw the amicus announcement that went out in this case, and it seems to me that that issue doesn't need to be addressed. It's an interesting, undecided issue. The restatement has a lot of interesting things in it. But here, the reason the derivative claim survives is because it's not the claim that Mullins brought the first time around in Cobble Hill 1. And you know, I take the point that the complaint doesn't mention the takings, but if I may there, when the Cobble Hill 2 case was filed, the case was effectively stayed as soon as the defendant's answer was filed. That's according to the appellee's brief at page 11, while Cobble Hill 1 was proceeding. Cobble Hill 1 gets decided. Then the Cobble Hill 2 court stays the hearing on stays the case and puts the motion for judgment on pleadings on hold until the Cobble Hill 1 appeal is decided. In March of so now we're in March of 2019. Case is stayed. The takings occurs. The appeals court decides Cobble Hill 1 the next month in April, and the Cobble Hill 2 court decides the motion for judgment of pleadings on the papers. My position is that the court, given the unique posture of this case, one case proceeding, the other one sort of in limbo, stayed informally, stayed formally, that the court should not, need not, and I say should not, blind itself to what actually happened to this property, particularly on a complaint that fairly read says, this property is going to waste. No one's doing anything about it. No one's listening to me. This claim should be heard. It is very different than saying this 2014 project shouldn't be going forward because I don't like it and I don't consent. We know life did go on after October 2016, and we know what happened to the property, and those claims have never been heard by anyone. And what's the alternative?
Mr. Albano, it appears your time has long expired, so we're
Oh, I'm
gonna.
sorry, forgive me.
No problem. We're gonna move on to Attorney Levin.
Good morning. May it please the court. Good morning, Chief Justice Budd and Associate Justices. I represent Gary Jennison, one of the appellees in this action, and I had planned on addressing the question for which the court asked for amicus briefs. But it seems that Mr. Albano has largely conceded that the corporation is bound by the factual findings from the initial case and has turned this into a factual argument as to whether or not those are dispositive. And that Mr. Falvey will be addressing. But I did want to touch upon a few things briefly that he did mention. The restatement, first of all, I agree with Mr. Albano that the court need not adopt the restatement in order to decide this case in favor of Mr. Corcoran and Mr. Jennison. And frankly, the restatement is entirely consistent with Massachusetts law on issue preclusion and merely provides a consistent framework for a presumptive analysis as to whether or not shareholders in a closely held corporation are in privity with the corporation. The one argument that Mr. Albano made was with respect to the comment E to the restatement, in which it talks about the fact that it's fair to bind a majority shareholder because he controls the company, and also bind the company to findings in a case involving the majority shareholder. But what we have here is the corollary to that argument, because in this case, it was Mr. Mullins who, as a minority shareholder, brought the first action individually. And here he's bringing the second action on a derivative basis. It's not the majority bringing the second action. It's Mr. Mullins on a derivative basis, bringing the second action and arguing the minority position. So it's the exact same situation that the restatement addresses, but instead of addressing it from the majority point of view, it's addressing it from the minority point of view. With respect to Whirlwind, if you actually look at the briefs, the defendant in that case argued that the plaintiff in the second case was actually a plaintiff in the first case. There was no argument of privity made in the Whirlwind case, and the court doesn't address privity. And the reason it didn't was because in Whirlwind, the defendant said, and I'm quoting from his brief, Whirlwind was/is the plaintiff in both actions. That's the brief that they filed with the SJC. And the court was merely saying, it's not, they're different parties. It wasn't a party to the first action. So nobody ever argued privity in that case, and the court never decided privity. And I think it's because of the words of the decision, it's been taken out of context. In terms of whether or not it's fair and equitable to apply issue preclusion to CHC, I think Judge Davis got it exactly right. This is a litigation involving all three beneficial owners of CHC. They were parties to the first case. They are parties to this case.
Counsel, could I interrupt you on that point? Because I'm interested in your answer on the discovery part of it. That's the part that troubles me the most. So the claims, at least individually to Mr. Mullins in Cobble Hill 2, were not allowed to be amended in Cobble Hill 1 to be added on the eve of trial. And one of the arguments that both you and Mr. Corcoran's counsel made was that It's too late. We haven't discovered any of these claims. We've had mountains of discovery in Cobble Hill 1 on the claims that were pled in the original complaint. We went through the discovery process. It's not fair to do that now. And so all of those claims were never discovered. Now he files Cobble Hill 2. That action is stayed and decided on judgment on the pleadings. There's never been discovery on those claims about the 2017 proposal. How can we say it was fairly litigated when it was never discovered? There were no depositions, no document requests, no nothing. How can we say it was fairly litigated?
So I think Mr. Falvey is going to address this more in depth, but I would say that the issues that were tried in Cobble Hill 1 are dispositive of the issues in Cobble Hill 2. For instance, the PQA proposal, the court in Cobble Hill, regardless of whether or not there was any discovery on that issue, although frankly, all the information was in possession of Mr. Mullins, he had the information, he made the proposal. The court said, after trying this and both parties putting in evidence, the court said, this violates zoning code. The city would never allow this. So their failure to go forward with the PQA and proposal, it doesn't give you anything in terms of mitigation because it couldn't go forward. That finding that it couldn't go forward, all the facts necessary for the parties to make that argument were presented to the court in the first case. And Judge Davis is—
That goes to the big picture issue, though, and I'll put aside the issue of the burden of proof, whether it's different on mitigation or not. But that's the big picture issue is your view is that these issues have been resolved in Cobble Hill 1. And I think Mr. Mullins' position is all through the prism of mitigation and not whether or not there was a breach of fiduciary duty, particularly post October 2016.
right, but
Does it matter? Does that matter that these are findings?
it doesn't matter because the factual finding was that these proposals couldn't have gone forward. What Mr. Mullins was proposing, by law, the city of Cambridge would not have allowed. And so regardless of what prism you look at it through, it wasn't decided on an issue of duty. What was decided upon was that regardless of what you were proposing, whether they ignored it or not, the city wasn't going to allow it. So not only did they not fail to mitigate their damages, but in this case, you can't say that you were harmed by any alleged breach of duty because the court has found in the first case that those proposals wouldn't have been allowed to go forward.
Not all the proposals that required zoning changes that were never going to occur.
Well, those were all the proposals that were referenced in the complaint, and Mr. Falvey will address this more in depth, but those proposals were all addressed in the first case. And Judge Salinger made findings on those, and Judge Davis based his decision in this case upon those findings.
Counsel, I understand that Mr. Falvey is going to address some of the factual overlap between Cobble Hill 1 and Cobble Hill 2. So I'm going to ask you a question about what you said you were here to discuss, which was the closely held corporations, derivative action being bound by the minority shareholders prior adjudication. Can I ask, you said we don't have to reach that in this case. Why not? Why wouldn't we? And what are the downsides to agreeing with the restatement of judgments?
Yeah, I'm not saying that you don't have to reach that issue. What I'm saying is the court need not necessarily adopt the restatement of judgment as the presumption.
Right, and I guess my question is, what's the downside? What policy would we be prohibited by, or what are the consequences of adopting the restatement of judgment position?
I think there are no negative consequences because in our position is that the restatement is entirely consistent with Massachusetts law on issue preclusion and privity, and it's merely a presumption that in the context of a closely held corporation, the shareholders are going to be in privity with the corporation. And so I don't think there's a downside. In fact, I think it's, as I've argued, it's consistent with Massachusetts law. if there are no other questions, I'll turn it over to Mr. Falvey.
Okay, let's do it.
Thank you.
May it please the court, my name is Bruce Falvey. I represent the appellee, the estate of Joseph E. Corcoran. As Judge Davis recognized and as the parties agree, the essence of issue preclusion is whether Mr. Mullins had a full and fair opportunity to litigate the factual findings that Judge Davis found precluded his claims because they're contrary to the core allegations of his claim.
So, Mr. Falvey, can I ask you to address Justice George's previous question, which is here the motion, motion to amend was not allowed, and your client's position was, yeah, we don't have discovery on this. It's not fair. This is a separate suit. Go file your separate suit, Mr. Mullins. And he did. Why is it fair then to say that he's suddenly precluded by what happened in Cobble Hill 1, given your position before?
Because when Mr. Mullins moved to amend his complaint, he did so based on the fact that no discovery was needed. He didn't need discovery. He said we didn't either because all the facts about his claims were known to us as well as him. So the discovery issue is really one that's a red herring, because although we made that point, he didn't believe discovery was needed. And it's then fair.
But you won, and so he wasn't allowed to bring in those claims.
That's correct. We won on the motion to amend, but the case did not stop there because despite the court's ruling on the motion to amend, the court denied our motion in limine to exclude evidence of events after the September 2015 close of discovery. The judge allowed Mr. Mullins to submit mitigation evidence of damages right through trial, and therefore Mr. Mullins was permitted at trial to introduce detailed evidence, and he did introduce detailed evidence of all of the alleged conduct on which the claims in this case are based. And the claims in this case—
Counsel, may I ask you one question about that before you go on?
Sure.
I understand did you object? I know you filed a motion in limine. Did you object to the use of this evidence later, or did it never come in to Mullins' satisfaction? What ended up happening there? Was it only admitted with regard to damages? Was it admitted with regard to liability? How finally is this objected to?
At trial, the evidence came in on liability for both sides, at least through September 2015. And then the judge allowed evidence thereafter, which I think fairly read on a review of the record went to mitigation, the evidence after September 2015. That's what it was supposed to come in for. Okay. But to answer your question and to answer the fairness question, is the proof positive that Mr. Mullins had a full and fair opportunity to litigate the claims that he asserts in this case is that after trial, in his closing and in his proposed findings and rulings, Mr. Mullins asked the court to rule not just on mitigation issues, but to rule on the merits of all of the claims asserted in the Cobble Hill 2 complaint. He asked the court to rule that our breaches of duty and of the contract included all of the conduct alleged in paragraphs 96 and 102 of the Cobble Hill 2 complaint. He asked us to be found liable for evicting tenants, for failing to disclose the second JPI offer, for not selling the land, and for refusing to consider all of the proposals that Mr. Albano mentioned and which are listed in the complaint. In this case, the PQA study, the DPZ study, the IPA study, the June 9, 2017 letter. He asked the court, and we cite where in our brief, he asked the court to decide all these claims on the merits, to rule that these were breaches of fiduciary duty.
I can interrupt you for a moment, and I want to ask you about the judicial estoppel in this context as well.
Sure.
On the merits, or as evidence as to the breaches within the time period alleged in the Cobble Hill 1 complaint?
I'm sorry, Your Honor. Could you repeat the question? I didn't get it.
Sure. All of these requests for findings, they were requests for findings as to the gravamen of the Cobble 1 complaint. not to what was pled as to breaches or breach of fiduciary duty or contract as to Cobble Hill 2, because that hadn't been filed yet. So you win on the motion to amend. You lose at least on the motion in limine as it relates to mitigation of damages. There's proposed findings of fact, and Mr. Mullen presents on those findings of fact certain things that have happened, and not as to the Cobble Hill 2 complaint, but as to the gravamen of the complaint in Cobble Hill 1.
But it's all of the same stuff that he alleged here. It was all of the claims that are alleged in paragraphs 96 and 102. And Judge Salinger in his findings, in his detailed findings, actually expressly rejected many of the claims that Mullins asserts in Cobble Hill 2. He found that we didn't breach by evicting tenants because we had a right to do it. He found that we did breach by not disclosing the second JPI offer, but that wasn't material. He found that we didn't breach by not selling the land because it should have been developed, but for Mr. Mullins, and he gave Mr. Mullins the financial benefit of the sale of the land anyway through his mitigation of damages ruling. And then he made mitigation findings explicitly as to all the other proposals that we supposedly didn't consider, finding that they were not feasible, and therefore the failure to consider them would have been immaterial as well. And he made those findings specifically as to the DPZ study and the PQA study. He found that with respect to the IPA analysis, that it was Mr. Mullins who breached, not us. In other
Counsel,
words,
if I could interrupt you one moment, because
Sure.
if you could point it to me in the record, on what basis did Judge Salinger find that the proposals weren't going to be feasible? Could you direct me to where the support was for that?
Sure. In the record appended at RA5, page 948, at trial, page 2183.
Could you summarize for me what that evidence was?
Sure. The evidence was that the proposed buildings that could not be built under the zoning code, and that there was evidence that it was highly unlikely, the judge found, that the property could be rezoned and that the building code would, or the zoning code would change.
That's what I'm getting at. That's what I'm getting at. What was that predicated on? Was that on witness testimony? Is that something?
We introduced the zoning ordinance itself, and there was testimony from witnesses about interactions with the city as to whether or not the zoning ordinance could be amended. And in fact, the judge cited a recent statement by the mayor of Somerville that the property should be rezoned to preclude any residential. So there was evidence about the zoning ordinance and about the possibility of rezoning.
I guess that's what my issue is. So that's a really big issue with this case about what kind of use could effectively be permitted in that area. And so to the extent that there's the finding on that, when there's been no discovery on that, yeah, there might be some things in there about what the mayor said and some other things about what they think that the city's going to allow or not allow. How can that determination be made with respect to vis-a-vis the feasibility of Mr. Mullins' proposal without it being discovered, without there actually being discovery on that?
Your Honor, it was Mr. Mullins who chose to submit that issue to the court to find that we breached by not pursuing those proposals. It was Mr. Mullins who asked the court that we failed to mitigate, that we acted unreasonably.
Sure, that's what I'm getting at, though. It was only allowed for the limited purpose of mitigation. So it was never fully litigated based on full discovery. It was just never done. So again, I'm getting back to the fairness of it. How could that possibly be fully litigated when there's never been any discovery?
because Mr. Mullins, who's the one who's precluded here, didn't want discovery on it, didn't think he needed discovery on it, submitted the issues to the court for decision, believing that he was going to win, that he'd had a full and fair opportunity to litigate them, and invited the very decisions that now.
If that's in the record, that as the fight about this in front of Judge Salinger, where if Mr. Mullins made some representation that he didn't need discovery, does that bind us from finding that this was fully litigated?
Well, the issue before the court is, did he have a full and fair opportunity? And so in deciding that, certainly whether Mr. Mullins himself concluded that he'd had a fair and full opportunity is completely relevant. And he obviously did, because he asked the court to decide the issue, not just of mitigation, but on the merits. And the court made the detailed findings that preclude his claims. And I do want to note that Mr. Mullins' claims in this case only go through the date of the filing of his complaint, which is July 2017. And the only post-October 2016 conduct that he talks about is the June 2017 letter. And that's in paragraphs 91 and 92 of his complaint. And those were addressed by the court because all that, as the complaint alleges in paragraph 91, what that letter did was analyze the PQA and the DPZ studies, and those were the ones that the court expressly found were not feasible. And that letter also endorsed 2 phases of the project, which the court found was also not feasible because only one building was allowed on the site. And again, the evidence which Mr. Mullins presented, and which we presented as well, was concerned the feasibility, and that issue was fully litigated. And he had a full and fair opportunity to litigate it. And he had every incentive to respond to you, Justice George, as to why it's fair. He had every incentive to prove that these projects were feasible, because that would mitigate his damages. And he attempted to do that, and he lost. And he doesn't get a do-over in this case, having made a strategic choice to introduce these issues into the case by opposing our motion in limine and seeking to introduce evidence of them. And then not only asking for mitigation rulings, but figuring that he'd done well enough that he could win on these claims. He made the strategic choice in his proposed findings to actually ask for rulings on the merits. And the court ruled on the merits as to many of the claims. And as to the rest, he made findings on mitigation at Mr. Mullins' request that are contrary to the core allegations of the claim and of his claims, and mean they cannot succeed. What our position does not mean that Mr. Mullins is forever barred from complaining about Cobble Hill 2. We are precluded, or he is precluded rather, from bringing this lawsuit, because all of the issues in this case were actually litigated, and not all of the issues, but there were findings on issues in Cobble Hill 1 that make it impossible here for him to succeed on his claims. But we agree that he's not precluded from bringing a new lawsuit based on events occurring after the May 2018 trial in Cobble Hill 1, which was a year after the complaint in this case. Contrary to Mr. Albano's argument, applying issue preclusion in this case isn't going to grant us a perpetual license that immunizes our conduct forevermore. But it does preclude all claims of breach based on conduct through at least 2017, which is the only claims that are asserted in this case. We actually know from the fact that Mr. Mullins is in bankruptcy, and there's litigation there where his attorney's invoices are a matter of public record, that he's planning Cobble Hill 3 to sue, having to do with the taking. And
Okay,
that's not precluded, because
Sorry,
to go
Sam,
to...
We're gonna just stop it there. I don't think that's part of the record. Thank you very much.
That's fine. Thank you, Your Honor.
For your arguments.
Thank you, Your Honor.